Namaskar, this is Tulja Bhavani. I welcome you all to my online classes in law, especially to the wing of business law. Dear students, this is a course which is designed for the BCom online classes, BCOC 133. Today we are going to learn about void agreements. Meaning of void agreement. It is defined in section 2 clause H of Indian Contract Act as an agreement not enforced by law. Dear viewers, yesterday I have explained you about enforceability. Enforceability means if either of the party to the contract are not in a position to perform their contractual obligation, the aggrieved party has a right to sue to file a case against the other party for performance of the contract. So, an agreement not enforceable by law, any agreement which is not having enforceability in it are the void agreements. So, there are some agreements which are void ab initio. Void ab initio means these are the agreements which are void from the beginning they have been made. They cannot be enforced in the court of law. They are void from the beginning. So, what are those agreements which cannot be enforced in the beginning are the agreements which we enter with a minor. So, any agreement if you are entering with a minor, that is called as void ab initio. So, there are certain agreements which are enforceable in the beginning, but later due to some circumstances they become unenforceable. So, when they are unenforceable, they are void contracts. So, when they have been entered, they are having all the elements of a valid contract, but later due to some circumstances they have become void. So, here you can see a picture of a child being played with someone, and you can find a ship which is floating on the sea. So, here dear viewers, any contract which is entered with a minor is void ab initio. Then any contract which is valid in the beginning, but later due to some circumstances it has become impossible for the promisor to implement his promise. Here you can find in the picture that a ship is flowing, it is floating on the sea and it is carrying the sugar bags in it. Here a contract has been made with by Mr. A and Mr. B. Mr. A has promised to supply the sugar bags to B provided that if his ship lands the port safely. Here the ship has not landed the port safely due to some cyclone problem. The sugar bags have been sinked into the sea. So, when the contract was entered between A and B, the contract was having all the essential elements of a valid contract, but later due to cyclone, the sugar bags have been sinked into the sea and the performance of the contract is not possible. So, dear viewers, here we are to discuss about the agreements which are expressly declared to be void. What are the agreements which are expressly declared to be void? So, here is agreements with incompetent persons. You are not supposed to enter an agreement with those parties which are incompetent to contract. So, what are those parties is defined in section 10 and section 11 of the Indian Contract Act. Then comes agreement entered through mutual mistake of facts between the parties. It means both the parties to the contract have entered into a contract due to some mutual mistakes between them. They are unaware of the mistakes which is done by them, and this is defined in section 20 of the Indian Contract Act. Then comes legality of the object and consideration. This is defined in section 23 till 30 of the Indian Contract Act. So, here is the agreements with incompetent parties. What are the agreements which we are not supposed to enter with the persons who are incompetent to contract is given in section 10 as well as in section 11. Dear viewers, section 10 speaks about those parties which are competent to contract. A contract to be valid, section 10 says that a contract to be valid, the parties must be competent to contract. It means there are few people who are eligible to enter into contract. Who are those parties? It means you are eligible to enter into contract with a major, you are eligible to enter into a contract with a person of sound mind, then you are eligible to enter into a contract by the person who is not having any legal proceedings against him, means who is not disqualified by the law in practice. This is said in section 10 of the Indian Contract Act. Then section 11 speaks that declares the following persons as incompetent to contract. It means you are not supposed to enter into a contract with a minor. You are not supposed to enter into a contract with a person of unsound mind. Then you are not supposed to enter into a contract who is disqualified by law in practice. You can see the picture here that a child is being being played with his father, and you can see a drunkard who is having liquor in the bar. So, you are not supposed to enter any contract with a child because child do not have maturity of mind. They do not understand the terms and conditions of the contract. Likewise, you are not supposed to enter into contract with a drunkard because the drunkard will be in intoxicated state. Then you are not supposed to enter into contract with a person of unsound mind. You can find the picture of Gajini here, who does not remember anything. So, he is a person having, he is a lunatic patient. His mind does not work. If some incident take place, then he gets mentally disturbed and he is not in himself. You are not supposed to enter into contract by any person who is disqualified by law, means who is a criminal. Then you are not supposed to enter into contract with an alien enemy. If India is having war with some country, you are not supposed to enter into contract with that persons or those countries. Then agreements entered through mutual mistakes of fact between the parties. Dear viewers, the word mistake is nowhere defined in the Indian Contract Act, but it is said that any action, decision or judgment that produces unwanted and unintentional results is considered as a mistake. It means you are not supposed to do any action, or you are not supposed to take any decision or give any judgment that produces the unwanted and unintentional result. If it does so, it comes under mistakes. So, the parties intending to do one thing, here in case of mistakes, the parties are intending to do one thing, but something is happening. So, parties intending to do one thing, by error some other thing is happening. For example, a police person has ordered his constables to catch hold of Mr. Ram, but they have catch hold of Mr. Shyam. In the picture you can find Dilip Kumar, राम एंड श्याम की जोड़ी है यहाँ पर, और पुलिस वाले ने अपने कांस्टेबल से कहा कि तुम जाकर राम को मेरे सामने ले आओ, मगर कांस्टेबल जो है वो राम के बदले श्याम को पकड़ ले आता है। और यहाँ पर आप श्रीदेवी को भी देख सकते हैं, यहाँ पर मंजू और अंजू की जोड़ी है। सो मंजू को बुलाने की बजाय हमने क्या किया, अंजू को बुला लिया। देन भैया मैं जब आपको आम के बारे में कह रही हूँ, मैंने आपको आम लाने के लिए कहा, लेकिन गलती से आपने सुन लिया जाम, सो इट इज़ ए काइंड ऑफ मिस्टेक। Then comes legality of the object and consideration. Dear viewers, yesterday we have discussed, in our previous classes we have discussed about the essential elements of a valid contract. So there are 11 essential elements of a valid contract which makes the contract enforceable in the court of law. So out of the 11 essential elements, all are very essential, but the most important is the object and its consideration. The object and its consideration should be lawful. If it is not lawful, it is said to be lawful unless it does not have the legality of the object and consideration is defined in section 23 of the Indian Contract Act, unless it is specifically forbidden by the law. There are 7 things which are given here, that is you can see in the screen. First one is specifically forbidden by law. Second one, if permitted would defeat the provisions of the law. Third one are fraudulent. Fourth one, involve injury to any person or property. Fifth one, the court regard them as immoral. And sixth one is are opposed to public policy. First one is specifically forbidden by law. Dear viewers, there are certain things which the law does not permit you to do. For example, let us take the example, in India, Hindus are governed by Hindu law and Muslims are governed by Muslim law, and those who does not come under Hindu law and Muslim law are governed by the English law. So, as per Hindu law, monogamy is allowed. A person can marry only one person. A person can have one spouse, and if he is interested to go for the second marriage, he has to divorce his first wife. So, in spite of having a living spouse, a person cannot go for second marriage. So, here I am taking an example of Mr. S, Miss L and Miss V. So, here S is a Hindu by birth and he marries L, who is his wife, and both of them are happily living their life. यस की पत्नी जो हैं वो यल हैं। यहाँ पर लव कॉन्क्वेट्स एवरीवन. मिस्टर यस आफ्टर गेटिंग मैरिड ही फॉल्स इन लव विथ ए लेडी कॉल्ड वी. So he makes an agreement with V that he is going to marry V. So here the act of marrying with V is void and it is against law, because the Hindu Marriage Act, as per Hindu Marriage Act, monogamy is allowed and a person is not supposed to get second marriage by having his first spouse alive. A person cannot get married to another woman until his wife is divorced or she is no more in this world. So this contract is a void contract. Then second one, if permitted, would defeat the provisions of the law. So if you permit certain acts, that is going to defeat the provisions of the law. To explain this concept, I will give you an example. Let us assume that there are two friends, Ram and Shyam. So Ram has built a home called My Sweet Home, and he is staying happily in his home. So he has not paid the municipal charges or municipal taxes of the home for the past few years. So the government, the municipality has decided to auction his home, and Mr. Ram makes a phone call to his friend Shyam saying that his house is going to be auctioned tomorrow. As he was the owner of the home, he cannot participate in the auction, and he requested his friend to participate on his behalf and take the home. Shyam comes and he participates in the auction and gets the home on his name. So when Shyam gets the home on his name, Ram comes to him and says that, dear friend, I requested you to participate on my behalf and take the home. Shyam said that yes, I have participated in the auction on your behalf, and now the home is in my name as I have paid the money. Now I am not going to transfer the home in your name. So you cannot force Shyam to transfer the home because he is the legal owner of the house now. Now the third one is are fraudulent in nature. So you are not supposed to enter into contract which are fraudulent in nature. Fraud means intention to deceive. You are cheating some person. So you are not supposed to enter into contract with the intention of cheating a person. Let us assume that there are two friends. Ram and Shyam, as I have told you. So Ram and Shyam, they goes to Visakhapatnam, which is famous for its Chor Bazaar. So in Visakhapatnam, both of these friends, they enter into contract with a person called Murthy, who promised them to supply the smuggled goods. So here, dear viewers, Ram and Shyam, both of them have paid 1 lakh rupee to Mr. Murthy, and Mr. Murthy has failed to supply the goods. Here Ram and Shyam cannot file a case against Murthy because they have entered into a contract which was illegal in the eyes of law. Smuggling is illegal, and selling of smuggled goods is also a part of illegal activity. Then fourth one is involve injury to any person or property. You are not supposed to enter into any contract which involves injury to any person or property. Injury here is the damage which is done to a person or to his property. It is a tort, something wrong which you are doing to a person or property, it should not be done. Let us assume that there are two persons. The first name of the person is Sunil and the second name is Rohit Rajan. So both of them are friends and they have done a business together. Later, due to some monetary aspect, they have argued and they detached from each other. सुनील नायडू और रोहित जो हैं अच्छे मित्र हैं और दोनों मिलकर एक व्यापार करते हैं. पैसों के मामले में उन दोनों के बीच में कोई झगड़ा हुआ है और ये दोनों अलग हो गए हैं. अब सुनील क्या करता है, जो भी अपने मित्र की वीक पॉइंट्स हैं वो सारे वीक पॉइंट्स एक कागज़ में लिख लेता है और लिखने के बाद ये सुनील जो है रोहित राजन की ऑफिस के सामने जाकर इन पम्पलेट्स को बांटना शुरू करता है. सो सुनील नायडू इज़ डिस्ट्रीब्यूटिंग ए पम्पलेट विच कंटेन्स ऑल द पर्सनल सीक्रेट्स ऑफ रोहित राजन before his office. Due to this act, the image of Rohit Rajan falls in the eyes of the people and he gets depressed. He is being defamed by Sunil Naidu. So here the reputation of Rohit Rajan has come down and he is depressed very much. So you are not supposed to do any act which defames a person. So it has caused injury to the person. Mental injury is being caused. Defaming a person is against the law, which will cost you high and it is punishable. Then the court regard them as immoral. Dear viewers, you are not supposed to enter into a contract which is regarded as immoral. Let us assume that let us take the example of Mr. Shekhar, who is having a wife called Lakshmi, and he falls in love with a lady called Vani. So yes, should not make an offer to Miss Vani saying that you are not supposed to enter into a contract of marriage with anybody. You are not supposed to enter into marriage with anybody. So if you are making an offer that if you don't get married, I am going to pay you 50 lakh rupees. You are not supposed to restrict a person from getting married. So if the court finds them as immoral, then the court will stop such kind of contracts and they are regarded as illegal. Then the sixth point is are opposed to public policies. Dear viewers, there are few contracts which are made in the interest of the public. They are made to protect the peace and harmony of the public. So there are certain contracts which are regarded as void because they are against the public policy. Agreements opposed to public policy. So what are the agreements which are opposed to public policy? Here in the screen you can find that there are 7 agreements which are opposed to public policy. First one is in restraint of marriage, which is defined in section 26 of the Indian Contract Act. Dear viewers, the Indian Constitution gives a right to every person to get married to the person of their choice without any caste, without seeing the difference of caste, without seeing any difference of religion, because marriage is regarded as a sacramental bond where the two souls become one. Second one is in restraint of trade, section 27. Dear viewers, the Indian Constitution has given you the freedom to carry the business or trade of your choice from Jammu Kashmir till Kanyakumari. Nobody has a right to restrict you. Nobody has a right to restrict you from carrying the trade. If they do so, then it is regarded as an agreement which is opposed to public policy. Third one is in restraint of legal proceedings. This is defined in section 28 of the Indian Contract Act. You are not supposed to stop any person from carrying his legal proceedings. If something happens to a person, if he is the aggrieved party, he can file a case against the other person and can claim the damages. So you are not supposed to stop the person from carrying his legal proceedings. Fourth one, void for uncertainty. This is defined in section 29 of the Indian Contract Act. If you are entering into any agreement on the basis of uncertainty, it means if you are entering into a contract or agreement, certainty of the object is mandatory. Your object should be certain and your terms should be clear. They should not be unambiguous. If I am saying you that I am going to sell you my car, it means the existence of car should be there. Illusionary words should not be spoken. Then to commit a crime, this is crime. Crime is an illegal act which is considered as an offense and it is punishable in the court of law. So you are not supposed to commit any crime. If two or more people they join together and plan to do something which causes a problem to another person, this kind of act is called as a crime and it is an offense, and the people who plan together to do such kind of things are called as the conspirators. Then with an alien, you are not supposed to enter into an agreement with the aliens. Aliens are the foreigners. There are two types of aliens. One are friendly aliens and other are the enemy aliens. You are not supposed to enter into contract with the enemy aliens. If you are entering into contract with the alien, at the time of war your contract is declared as invalid, and if you are entering into contract with the alien, if you have already entered into contract with the alien before the war, so your contract will be suspended until the war is over. Then seventh one is wagering agreement, which is defined in section 30 of the Indian Contract Act. The word wager means betting. So here a person bets for the happening or not happening of certain events. So under wagering there are certain exceptions like contract of insurance, then any contract, any agreement which is contract of insurance is not regarded as wager because here our intention is good. Then horse races does not come under betting because horses, they win the races depending upon their talent and hard work. Then there are certain competitions which require a lot of preparation. Then thank you so much for giving me this opportunity. Jai Hind, Jai Bharat.